Domestic violence charge? Jail isn't your only problem.
Have you or someone you know just been charged with domestic violence in California? Before you panic, let me tell you, you're not alone and you do have options. In this video, I'll break down exactly what to expect, what mistakes to avoid, and how you can fight back. Stay with me because what you do next could change everything. First, let's get clear on what you're facing. In California, domestic violence is taken very seriously. The most common charges are Penal Code 243E1, domestic battery. This is a misdemeanor offense where any unwanted physical contact can lead to charges. No physical injury is required. There is also Penal Code 273.5, corporal injury to a spouse or cohabitant, which makes it a crime to willfully inflict a corporal injury that results in a traumatic condition on an intimate partner. This means causing any physical harm, such as bruises, cuts, or broken bones, to a spouse, cohabitant, co-parent, or dating partner. Of course, the more serious the injury, the more exposure the accused can face. For instance, if a bone is broken, the district attorney will likely add a GBI enhancement, which significantly increases the severity of the case. Facing domestic violence accusations can profoundly impact your life, affecting your freedom, relationships, and reputation. These allegations often involve claims of harm or threats against intimate partners, family members, or cohabitants and may include physical violence, emotional abuse, or harassment. California law takes these cases seriously, imposing harsh penalties such as jail or prison time, substantial fines, mandatory counseling, firearm restrictions, and more. And here's the kicker: even if the alleged victim doesn't want to press charges, the prosecution can still move forward. Once you're arrested, the case is largely out of your hands. That's why what you do next is critical. Domestic violence charges can be classified as misdemeanors or felonies depending on the severity of the injuries and evidence. Both misdemeanor and felony domestic violence convictions carry harsh penalties such as incarceration and lasting consequences like deportation, loss of custody, and loss of firearm rights. If you're watching this, you're probably feeling overwhelmed, frustrated, and confused. Here are some of the frequently asked questions our clients raise. Will I go to jail? Jail time is possible but not always inevitable. With the right legal strategy, charges can sometimes be reduced or dismissed. Will I lose my job? A conviction can appear on background checks, but legal defenses exist to protect your future. It is imperative that you inform your attorney whether you possess a professional license that could be impacted by a domestic violence conviction, and work to mount a defense strategy that avoids administrative actions on your license. Can I see my kids? Protective orders can affect child custody and trigger a presumption that custody should not be given to the parent with a domestic violence finding. But there are ways to fight for your parental rights and rebut that presumption. What if I were falsely accused? False accusations happen more often than you think, and they can be challenged with substantial evidence. Will I lose my gun rights? A domestic violence conviction will result in a permanent bar on your ability to own a gun. If your right to bear arms is important to you, then you must fight these accusations to the end and avoid a domestic violence conviction. Now, let's talk about the biggest mistakes people make after being charged. Talking to the police without a lawyer. Anything you say will be used against you. Stay silent and ask for an attorney. Contacting the alleged victim, even if you just want to explain, this can violate a protective order and worsen your case. Posting on social media, prosecutors can use your posts as evidence, even if they seem harmless to you. Assuming the case will go away, ignoring it can lead to harsher penalties or delays in the investigation. You need to take action now. So what should you do instead? Let's talk about ways you can protect yourself. Gather evidence, save texts, emails, and any proof that may support your case. Follow court orders carefully. Violating them can make things worse. When police respond to domestic violence reports, arrests are frequently made based on conflicting accounts or limited evidence. Emergency protective orders may be issued immediately, barring the accused from returning home or contacting the alleged victim. These orders can evolve into longer-term criminal protective orders, restricting your freedoms throughout the legal process. Whether you agree with the issuance of the order or not, it is critical to abide by it while in place, or you can face additional charges. Stay calm and don't engage in arguments. Anything you say can be misinterpreted.
And finally, hire an experienced domestic violence attorney ASAP. The sooner the better. A good defense strategy can mean the difference between a conviction and a dismissed case. A strong defense attorney can challenge the evidence and fight to get charges reduced or dismissed. Negotiate for alternative sentencing to avoid jail. Protect your record, your job, and your future. And remember, just because you're charged doesn't mean you're guilty. If you or a loved one is facing domestic violence charges, time is critical. Don't wait. Get legal help now. We've helped many people in your exact situation, and we can help you too. Call now for a consultation. Like and share this video and subscribe to our channel for more legal tips and updates. Remember, what you do next could change everything. Thanks for watching, and I'll see you in the next video. Don't forget to like and share this video, and for more legal insights, keep watching and subscribe to our channel.